how should rideshare drivers be classified? That is the question at the heart of Massachusetts' lawsuit against Uber and Lyft, which kicked off in court today. Attorney General Andrea Campbell argues that companies misclassify their drivers as independent contractors rather than employees who are entitled to many more benefits, including minimum wage, overtime, and sick pay. Lawyers for Uber and Lyft argue that their drivers don't fit into a traditional employee role. They're also behind a state ballot question that would establish a law declaring their drivers independent contractors. GBH News State House reporter Katie Lannan was watching the proceedings in court today. She joins me now to help break all of this down. Hello, Katie. Good to see you as always. So this case was filed way back in 2020 when the Attorney General was now Governor Maura Healey. Finally coming to trial now. What did the respective sides have to say in their opening arguments?
So these are not new arguments at this point, and they're ones that we've heard play out in the State House and in campaign commercials even at this point, that what Uber and Lyft are saying is that they operate, rather than a transportation company, you know, they're not a taxi company. They say they operate more like Airbnb or Etsy.
Decentralized clearinghouse for individuals who want to do things?
To connect, you know, they describe their drivers as entrepreneurs who want to be able to set their own schedules, who might have other jobs or family obligations or personal interests and schedules to work around. And they say that flexibility is what draws people to this job, and it's a key component of the contractor model. Now, what we're hearing from the state, from the Attorney General's office, is that Uber and Lyft have a level of control over each ride. They have a level of data and a level of involvement that doesn't square with the contractor model, that the ride is the product that they're making their money off of, and that they have loyalty programs, financial incentives, and other ways to kind of shape drivers' behaviors, schedules.
So very hands-on as opposed to laissez-faire. That's the contention from the state.
Right.
By the way, the state's Fair Labor Division, this is in the Attorney General's office, this is just interesting for people to ponder. They say this is what it takes for workers to be treated as contractors. Work has to be done without the direction and control of the employer. Work has to be performed outside the usual course of the employer's business, and the work is done by someone who has their own independent business or trade doing that kind of work, which obviously ties into everything that you just mentioned. There is another ballot question. I mentioned the ballot question up top that is backed by the industry. There's another one that is opposed by the industry and is intimately connected to this lawsuit that we're talking about right here. What is that other ballot question?
Sure, and this is where it all gets to be a little bit of a tangle, right?
It's very messy. Yeah.
But the ballot question you're referring to, which is backed by labor unions, who also oppose the other ballot question, but we'll talk about that later. And this ballot question would let Uber and Lyft drivers unionize under the state's collective bargaining laws. And one of the things that we've heard from in various discussions about this is that this ballot question, the unionization push, is designed to kind of stand either way, whether ultimately under state law drivers are contractors or employees, they'd still be granted this collective bargaining right if the voters sign off.
I see. So it was crafted with this court fight that we're talking about in mind, and so it could weather whatever the outcome is.
Yes, and since, you know, this court fight has its roots way back 4 years ago, it's something that is really at the heart of all the discussions, and it's never too far from the front of anyone's mind.
There is a precedent for the rideshare companies, if things happen in a particular jurisdiction that they don't like, regulatory steps are taken, whatever they may be, of taking fairly drastic action. Can you just offer a super brief description of what's happened elsewhere in one or two cases?
Yeah, there was an instance a few years ago in Austin, Texas, where Uber and Lyft pulled out of that city for about a year over concerns with a fingerprinting requirement for drivers. And they ultimately only came back when state-level legislation was passed to change that. They've also said that, you know, we could see as soon as this summer, those two companies leave Minneapolis over a wage ordinance there They're kind of waiting to see what happens, again, legislatively. And the possibility of Uber and Lyft pulling out of Massachusetts is something lawmakers have asked about when they had the company executives in to testify. They didn't get a clear answer in their questioning. So it does seem like that is something that's on the table, either as a reality or as a bargaining chip.
You know, it just occurred to me, I am no attorney, as you know, but I wonder if Uber and Lyft's willingness to pull out of certain markets might be used by people who disagree with the rideshare companies on this question of whether their workers are employees or contractors. Because if the entire company can pull out, if it's not left up to individuals, again, thinking out loud here, but that's an argument that seems to potentially undercut the contractor claim that the rideshare companies make. Okay, just to make things even more confusing, there is that ballot question that's backed by the industry, and it would do what exactly? So
even the exactly part of that question is a little tricky to answer because...
It's a terrible question, too, because it kind of puts you on the spot. So what would that do?
The reason I can't give you an exact answer is because there are multiple versions in play. The question was knocked off the ballot. A similar question was knocked off the ballot in the previous cycle. It didn't meet the qualifications. So this time around, the industry-backed group is putting forward multiple versions of the question. I believe there are 5 in play, and they range from just defining the drivers as contractors to some alternative versions would grant them new benefits along with cementing that contractor status.
Okay. What happens if the judge in the case that just kicked off today, finally after 4 years, what happens if that judge says, yes, in fact, the drivers are employees? And what happens if then, later on this year, voters pass a ballot question saying, in fact, rideshare drivers are contractors? How would that conflict be resolved?
Well, I think we still continue to have trouble talking about what goes on in that situation, more confusion. But it is worth noting and being clear here that the ongoing trial is about current state law and what is required under current state law. Okay. The ballot question would create a new law, so that would be kind of forward-looking. The Attorney General's office has said that if that scenario plays out, if the lawsuit says they're employees and then voters decide they should be contractors, there'll still be a retroactive period of benefits that were due when the drivers
really interesting.
Were employees but classified as contractors, and they'd go after those benefits. They'd seek to have that paid.
I never would have thought of that as being a possible wrinkle. That's really interesting. Okay, both these questions, ballot questions that are headed in the general direction of voters later this fall, they're both being challenged at the Supreme Judicial Court. What is the grounds for the challenge that is being brought by people who don't like the anti-industry measure and who don't like the pro-industry measure?
This is the most common reason you see ballot questions challenged in court. The idea with the ballot question system is that what is presented to a voter when they're in the polling booth, it's something that should be one coherent policy, and your average person can look at it and say, I want that or I don't want that.
All this stuff fits together.
Right. The challenges for both ballot questions or both sets of ballot questions argues that they don't do that. They mix too many different parts, and it would be, a voter might want Section A but not want Section B and not be able to square those two ideas. So we'll hear from the court relatively soon, within, long before Election Day, whether those are eligible.
I know that there is another of the many ballot questions that have popped up in this cycle. There's another one that's being challenged at the SJC. What is it?
Yes, that one would phase out the lower sub-minimum wage for tipped workers and replace that with the state's full $15 minimum wage for people like waitstaff in restaurants. The argument that critics of that question have brought is that it also includes a section on tip pooling that would allow, say, a restaurant owner to require that tips be shared between not only the waitstaff but also the dishwashers or the other folks in the back of the house.
And does that bring up the relatedness challenge again,
same
or question?
Issue. We're not sure the court will go along with that. There were in last week's arguments, there were a few instances where the justices seemed to say, yeah, this is all about the law on tips and how tipped workers are paid. So a voter could look at that as all one issue. So we'll see what the court decides there.
I always have a hard time when I'm watching those arguments at the SJC figuring out what the justices are thinking. Now, just to be clear about this minimum wage for tipped workers provision, which we may end up voting on this fall, it's worth mentioning to people that under current law, you're supposed to get paid at least the minimum wage if you're a waiter, right, or a bartender. If your tips don't bring you up to a minimum wage level of payment on an hourly basis, you're supposed to be compensated by your establishment, right?
That's right. It would fall to the employer to make up the difference. And the idea behind the ballot question is no matter what, you'd be making $15, and any tip you got...
Just as a baseline.
Yeah, any tip you got wouldn't bring you up to that baseline level. The tip would be on top as a true bonus. The supporters say that way it's the employers who are paying the cost of employing their workers. It's not on to the customer. And they also say that it's hard in the restaurant industry to know if you're being paid correctly under this model, and that leaving workers dependent on the customers for so much of their pay creates a system where they're vulnerable to bad behavior from guests. So, and then meanwhile...
You got to take abuse effectively.
Right, yes. And then you have others in the restaurant industry who like the way they're getting paid, who are, feel as though they're making good money with their tips as is, and are wary about the idea of tip pooling, or just don't want to change from the current system.
I guess if you are a really, really terrific waiter, waitress, bartender, and the system's working for you, why bother to get rid of it, right?
Yeah, and it depends too on, probably the type of place where you work. The typical cost of a bill, of a meal out, varies dramatically. So I'm sure there's variations in what people receive on any given night.
Yeah, that makes sense. All right, Katie Lannan, thank you for helping me and hopefully some viewers to untangle this very, very complicated knot of stuff. Appreciate it.
Thanks, Adam.